Good morning, everybody. Pink Camera Magic here, and welcome to my channel. I wanted to make this video quick here just to address a few things that have been talked about recently in some forums. I know there's been a lot of discussion regarding my case in Cook County. For those of you who don't know, I was arrested outside the Cook County courthouse for recording. I was never charged with a crime. I ended up suing them, and the federal judge dropped our case. So here's a couple things that I wanted to go over. My case fell apart largely due to General Administrative Order 2013-01 regarding cell phones and other electronic devices. This order was put together in an effort to stop witness tampering. This administrative order does not apply to my situation. This only applies at the Layton Courthouse. The Layton Courthouse is the main courthouse in Chicago where they have a lot of their big cases. The one that I was at was the Bridgeview, and that's a smaller suburban courthouse. The highlighted sections talk about exemptions, so I want you to go ahead and take a look. Pay particular attention to the second exemption. The following persons at other circuit courthouse facilities, all of whom must have proper identification and be on official business in the courthouse. I had court that day. I was addressing 3 traffic tickets. Social visits and business for the purpose of addressing one's own private personal interests are not considered to be official business. Since described in Section 2, may use the telephone, SMS, short message service, texting, instant messaging, email, word processing functions of a cell phone or other electronic device only in the public areas of the courthouse, outside the courtrooms, and said electronic devices must remain off when inside of the courtrooms, unless otherwise expressly permitted by the judge presiding. At the time, of course, as you all know, I was recording outside. Now I want you to take a look at General Administrative Order 2013-05. This one actually is the one that applies, and this is the one that actually shows the address. It shows at the bottom of the first paragraph, the George N. Layton Criminal Courthouse is where this rule applies. And it shows it right there at the bottom. And is dated April 10th, 2013, and it's effective April 15th of 2013, which is after the one that was submitted as evidence in court. So just to be sure, I went over to the facts section on the Cook County Court website. The very first question is, are all courthouses under the ban? It clearly says that at this time the ban is in effect only at the Layton Criminal Courthouse. And just below that it says the ban is currently not in effect at the following courthouses. And if you scroll down, you see how I highlighted it there, the 5th Municipal District Bridgeview Courthouse. Take a look at the decision. I'm not going to go too in-depth with this because I did a video on it already, which I will have linked in the description of this video. We had 10 claims. Claims 1 and 2 have to do with First Amendment retaliation. Claims 3 and 4 have to do with the detainment and arrest. Claims 5, 6, and 7 have to do with Fourth Amendment violations with them searching my purse and camera. And number 8 through 10 have to do with training and their policies. They established that they had reasonable suspicion to detain me. In this case, it said that Officer Barbero testified that he observed me scanning back and forth with the camera, up and down, people coming in and out, possibly videotaping through the glass at the security post. According to him, the courthouse installed cameras outside after the 9/11 attacks. They talked about the air system, stuff like that. And so what they're saying basically is that a reasonable officer would have suspicion that I was in violation of disorderly conduct. Officer Dvorak claimed that from the outside where I was standing, you can see inside and see all the security systems, the x-ray machines. I don't know. Does this support his claim that I can see all the equipment inside, or my claim that I was actually recording myself and practicing my panning shots? Now let's look at this. This is regarding the decision. Now it says, relevant here, a general order applicable to Cook County courthouses, an order that was in place in March of 2018, provides, except as noted below, all mobile computing and telecommunication devices, including but not limited to cell phones, smartphones, laptops, etc., and other devices, they're prohibited in the Circuit Court of Cook County, Illinois General Administrative Order number 2013-01. And you notice it said, except as noted below. He did not include those exceptions. One of the mistakes I made is that I didn't actually invoke my Fifth Amendment right verbally, and it's because of that they used my silence against me and considered it being evasive. It was for that they prolonged the detention. The decision says that the same events that supported reasonable suspicion also supported probable cause for my arrest. But remember, I was never charged with a crime. And it says that a reasonable officer had probable cause to believe that plaintiff violated the general administrative order prohibiting filming inside of the courthouse, as well as the Illinois statute prohibiting disorderly conduct. So the judge terminated my case for the detainment and arrest. They granted the officers qualified immunity on some of my Fourth Amendment claims, and on the others, it was granted due to a search subject to arrest. On my First Amendment retaliation claims, they couldn't go through because of the fact that they were able to establish probable cause and reasonable suspicion, and because of that, I would be ineligible for those. And the judge dropped the rest of the claims before they could even be heard. So that is their reasoning why my case was terminated. It was because of terrorism and my evasiveness for remaining silent. However, it just happened to slip under the radar that the judicial order that everything was based off of did not apply to me. I could have been a lot more proactive in my case, which I highly recommend that you do, but that's what you hire lawyers for. That's why they get paid the good money. And you would think that between a person doing what I'm doing, a good attorney, a lieutenant, a sergeant, and 2 judges, that little detail would not have slipped through the cracks. At least that's what you would think. Had I known this at the time of the appeal, I would have done whatever I could to go through with it, but at the time, it just didn't seem like the right thing. Also, at the time, there was a lot of changes happening when it came to my representation. My lawyer actually started to partner with somebody else, and so someone else actually ended up taking over my case, who I never really spoke to about it. At the time, they also wanted to change my contract as well, so there was a lot of those kind of details that I think played a role in this. But also, I just don't have the money, resources, or time. Like, I couldn't do it. It just seemed like the right thing to do to take this small settlement. However, there isn't very much satisfaction in getting a payday. My reward came with releasing those depositions, because that's what this is all about, exposure and education. And I'm pretty sure that the sergeant and the lieutenant got a pretty good education this time around. I know there were some changes made, there were some policy changes, there was some training involved, so I would call it a success. Thanks for watching, guys. Have a great